What's up, everybody? We are back here with another episode breaking down the latest in Sarah Boone's case. We have the final motion, I believe, that she has filed pro bono prior to her attorney starting, but it finally got into the court docket now. Sometimes that takes time. But more interestingly, we have some back and forth here and some motions about potential pro bono work with no expectation of getting paid in the future, which directly contradicts what their lawyer said in the past. We're going to take a look at those motions. We're also going to take a look at the Florida Bar rule on ethics and how we deal with pro bono, what it's supposed to be, what it's not supposed to be, what it can be, what it can't be. And then a very interesting notice of unavailability filed by the prosecutor. And the date is of interest to me. So we're going to break that down at the end. Make sure all of you guys hit the like button if you haven't already. Let's jump into it. So a lot going on in this case as per usual, but I found the timing and the content of Sarah Boone's potentially last pro se motion because we know right around this time she has been talking to her current lawyer, James Owens. We also know that James Owens has told the court that he is going to make some arguments against some of the documents and videos and evidence that the state is looking to enter. I think he specifically mentioned recordings, interviews, things like that. So we know some of those arguments are coming. By the way, when a pro se defendant files something like this, they can just withdraw it, replace it with another motion. Logistically and procedurally, there are things you can do that. It doesn't necessarily have to be set for hearing. The attorney doesn't have to argue it the way that the pro se defendant wrote it. It's just, more time and energy and things to do to correct stuff that's happening in this case already. But let's take a listen to this. Motion to object by the defendant to the state's digital evidence, USB jump drive. Comes now the defendant, Sarah Boone, by way of pro se, respectfully requests from this honorable court that my motion be heard as to my reasons why I am objecting to the state's evidence against me and to exclude or limit the following particular items attempting to be admitted into my criminal case by the state. Pretty good opening shot. Objections are for digital contents specifically and only located on the USB jump drive titled as, here's the title. Number one is the suitcase videos. We know what those are, 3 of them. We have another video in the playlist for Sarah Boone where we break this down. We watch this together. It's brutal. It's terrible. It's horrible. And actually another video where we get another perspective on this coming in the future prior to trial, but not this week. So keep an eye out for that. These files were obtained from my personal cell phone. There are no videos located in this folder on the jump drive. Then she lists the name, photograph of the suitcase, 2 minutes and 3 seconds, and then 22 seconds. Now, if they're not there, potentially if the state doesn't turn them over to her in time, they could be stricken, things like that. But now they're working with the lawyer. We're going to see another motion here where they've turned over a lot of this to the lawyer. We'll see if they can figure it out, get it all working so everything's playing. Absolutely have to have that. Can't be putting things in at trial that the defendant has never seen or doesn't work for the defendant. So they absolutely need to get that fixed. But she has some specific objections here. Did she come up with these on her own? Did she have help? Did Owens help her? Did somebody else help her? Who the heck knows? Lack of authenticity. There is no one to testify that the picture and audio are the same as the scene was at the time the audio was recorded and photograph taken. So this would indicate maybe she's not going to testify because they could obviously ask her if she decides to testify, even if in a narrative form, they can cross her on it. But this is an interesting argument, right? She's like, can't authenticate it. How do we know this was in the location at the time? How do we know the audio happened the same time as the video? Did they have an expert break all this down and say it hasn't been tampered with? Well, it's interesting. And sometimes things like this can be difficult to prove. But in a case like this, when she called law enforcement to the scene, they saw the suitcase, they saw the contents of the apartment, they saw George's body, and they photographed it. I'm sure. I haven't seen the photograph, but we heard that there are crime scene photographs. We've heard that the defense may be even hiring a expert crime scene reconstructionist for this situation. But they are going to be able to show that this was the apartment. This is how it was. This is where the suitcase was. And my guess is the phone has a timestamp or some kind of report to show when that recording was made and where it was made. Do they? I don't know. I haven't seen it. We haven't seen all the evidence. But my guess is the state has evidence to prove the authenticity of this video. The prosecution fails to establish the authenticity of any of the three items submitted. She cites Florida statute supporting case law. The next argument to keep this out is it is potentially unfair prejudice. I believe that the singular reason to utilize this audio is for the state to heavily prejudice the jury against me. So we talked about this before, and judges like to say it sometimes when they rule on motions like this. Every piece of evidence the state puts in is going to be prejudicial against the defendant. Every piece of evidence the defendant puts in might be prejudicial against the state or good for the defendant. That's not how it works. It has to be unfairly prejudicial, meaning random, not relevant. It just inflames the passions of the jury. That prejudice has to be weighed with the probative value. And what is the probative value of these videos? Well, number one, it could prove that she knew he was in there. It could prove she knew he couldn't breathe. It could prove criminal intent. It could prove the difference between manslaughter and second degree based on her verbiage. She says, based on my statements in the audio to George Torres. It's prejudicial. They only want to prejudice me by using my own statements against me. You're probably right, Ms. Boone. But when you weigh that against the probative value, which is potentially the biggest piece of and the most probative piece of evidence in the entire case, my guess is you're not going to win this balancing act. The prosecution's evidence is more prejudicial than probative. She cites Florida statutes and some case law. And then lastly, a violation of her Fourth Amendment rights, unlawful search and seizure. This audio was obtained by an unlawful search and seizure of my personal cell phone, and the defense moves to exclude it under my Fourth Amendment right. So one of the issues with this is, I think I remember, I'd have to go back to confirm, but I think she voluntarily turned over her cell phone. I could be wrong about that. It could have been search incident to arrest, but I believe that she turned over her cell phone. She was being very cooperative. She answered questions. She did an interview. I'm sure some of you guys remember whether or not she turned over her cell phone. I believe she did. And if you do that voluntarily, that makes a lot of these arguments null and void or very difficult to continue. All right. Next, we have body cams, 4 items, and she lists them out. Once again, she says lack of authenticity. All of the body cam videos obtained from uniform officers on the date of the incident are time-stamped and documented incorrectly during the entire use while at the scene. So I haven't looked through all the body cam. We've seen some of it. I don't know specifically what she's talking about. If there are dates that are wrong, or maybe it's military time, maybe it's UTC, who knows? We're going to need to get an explanation from this. But even if the time is wrong, the officers would still be able to authenticate. This is an accurate depiction of the scene that day, that time. I was there. This is my body cam. I turned it on when I showed up or before I showed up. This is an accurate representation of Sarah Boone on that day. There are ways to authenticate this, even if the timestamp may be wrong, which we've seen trials where some timestamps have been wrong. Violation of the best evidence rule. So what is the best evidence rule? The best evidence rule is if you have access and it's easily ascertainable to the best evidence, you have to use that best evidence. You can't pick and choose lesser credible or lesser authenticated versions of the best evidence, meaning playing an audio tape versus having somebody come testify, having somebody explain what's on a disc versus just playing the disc. You have to use the best evidence you can, the most credible evidence, the most objective evidence. Now, there are different ways in which this can be used. We'll see kind of the arguments that she makes. The state fails to provide the best version of the evidence. Under the best evidence rule, the state has not provided the true and accurate video evidence, and the defense moves to exclude these body cam videos. I don't know if she means the best evidence is them testifying, because sometimes I would disagree, and it would be the inverse, that the body cam is actually better evidence than them testifying about what they saw. But, obviously you can see things, different angles, and you can move your head, even though the body camera is just facing forward. So I understand the need for both. It's customarily allowed in basically every case. She says it's not accurate. I'm trying to figure out if she means that she wants to play the full video. She doesn't want the redacted version, but they need the rule of completeness or completion. Maybe she's looking for something like that as the best evidence. Maybe she means it's the best evidence for her. I don't know. But she cites some case law. Violation of Miranda rights. The body cam videos recorded of me making statements and providing information prior to me being given any Miranda warning. These are alleged interrogations and a violation. These are illegal interrogations and a violation of my Fifth Amendment right and should be excluded under the exclusionary rule. So these are some of the things, in my opinion, that you can picture Sarah Boone telling her lawyers, we need to do this, we need to file these motions. And they're explaining to her, like, it's got to be a custodial interview. Were you in custody? Were they interviewing you? Were they asking you questions that would incriminate yourself? Were you free to go? And I think there may be some legitimate digging that needs to be done around this. I don't know the answer. I don't think she was free to leave, but they didn't put her in cuffs. They didn't immediately put her in the back of the squad car. They did eventually. They read her Miranda rights before the interrogation at the police station. So even if they did have to lose what she said at the scene, they would have the all the statements made in the interrogation room. But I think, we would need more information. I can't remember off the top of my head all of the context around the conversation outside of her apartment. Usually just, asking, hey, what the heck happened is not necessarily considered a custodial interview or a custodial interrogation. But we'll see what her lawyer can come up with as far as research and getting more context about what happened at the scene. Additionally, I'll say that I do expect her lawyer to file some sort of motion similar to this, but with more pointed, legitimate arguments, motions in limine, trying to keep certain portions or certain things out, or ways that the state may be able to argue or not argue some of this evidence. Next is defendant's interviews. I believe this is the interrogation she's talking about at this point. Video of Sarah Boone interview. Lack of authenticity. The interrogation video has no timestamp throughout its entirety of 2 hours, 6 minutes, and 3 seconds. And again, these may be different versions than we've seen. And these should be the official versions. What they're turning over to her should be what they're going to use at trial. The exhibits, they should be legitimate. They should all be right. If there are issues, they need to fix those. But obviously, the officers in the video as well can authenticate them. They can authenticate them, date, time, and place. They probably have noted on their police reports, what time all this stuff was happening. So there are ways to still authenticate it. Violation of the best evidence rule. Again, state fails to provide the best version of the evidence. Under the best evidence rule, the state has not provided an accurate video evidence, and the defense moves to exclude this interrogation video. The defendant requests that the due date be extended to submit objections based upon. So this is before she had a lawyer. She wanted an extension. Very reasonable, and she gives some of the reasons here. I think the judge would have granted this, and I think the judge did extend some of the deadlines already, even though he hasn't continued the trial. Here are some reasons she thinks it needed to be extended. She is unable to utilize her Sixth constitutional amendment right to counsel, has never been pro se before, is not an attorney or officer of the legal system, lacks requisite professional competency, experience, expertise in the legal field, is currently incarcerated, has extremely limited and restricted resources to conduct extensive legal research to further support objections, no internet, does not have full-time use of or access to the laptop, does not have full-time use or access to the tablet, does not have access to privacy temporary for in-depth review of discovery, has limited access to defense team investigator to collaborate and complete greater work product. All those legitimate. If she needed more time to answer some of this stuff or object to some of this stuff, the judge should have, and I think would have granted it. These objections were done as expeditiously as possible based on my current circumstances. The process for a pro se defendant requires much more time, especially while incarcerated, than that of an unrestricted, well-educated, resourceful attorney who is fully capable and has all of the aforementioned availabilities. And so she got one, which is important and great, and she's right about this. Also, I reserve my reasons for my objections for an in-court oral argument. Again, that's appropriate. And I actually think she did a pretty good job in limited amount of time, having to rush it, making the best arguments she can, even though most of them are probably going to be losers. A lot of criminal defense lawyers make loser arguments because they make the best arguments they can. Also, I reserve my reasoning for objections for in-court oral arguments. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully moves this honorable court in conclusion to hear my reasons why I'm objecting to the state's evidence against me and to exclude or limit the included particular items attempting to be admitted into my criminal case by the state. And the oath, certificate of service, and this was on August 22nd is when this was filed. All right. Was there a hole in the suitcase? Bellin asks. Sarah Boone, I think, said she left a hole if he wanted to get out so he could breathe, whatever it may be. I think a lot of that stuff, those details are going to be hammered out in the trial. I see a lot of the keep the stash, become a Top Gun pilot, live your best stash life. Thank you, Emily, and to everybody else who supports the stash. Support the stash. We're going to hold strong here for a little bit. It's already growing back in, though, in case you can't tell. We'll see how it catches up. All right, let's get to the next document here. And I think one or two of these we may have already looked at, but they provide context to what we're talking about. Second motion for additional discovery. Under 3.220, additional discovery on a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense requests the Office of the State Attorney to provide standard Miranda rights, written policy form, and card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. So this to me indicates that they think there might be an issue with the Miranda rights, how they were read to Sarah Boone, when they were read to Sarah Boone. Again, this goes to similar to what she was trying to argue. I think James Owen is going to do it more articulately. No knock on Sarah Boone, but because he is a trained and skilled lawyer, as she said. So he's looking for the documentation to prove they did it wrong, to hope he can throw out all or part of the statements that she made. And that's what this is. And that's what this indicates to me that he's trying to do. All right. Next document. This isn't the one I want to do yet. Hold on a second. All right. So then we have additional discovery filed by the state to James Owens. 911 call, CAD, calls for service, domestic violence history. It's going to be big for their battered spouse defense. Incident reports, interviews, OCFD run sheet, OCME case synopsis, property forms, public video, search warrant, social media. 2 videos from her cell phone, CSC form, investigative report, sworn statements, cell phone logs, waivers and affidavits form from Sarah Boone, and then discs with interviews, calls, surveillance, videos, photos, suitcase video, device photos, ME photos, et cetera, et cetera. Sarah Boone interviews. Okay. And the reason I want to show you this is Sarah Boone was complaining she couldn't open some of this. She couldn't see some of this. Well, now it's going to go to James Owens. We'll see if he can open it up on his computer. We'll see if there are any issues with that. If there are, then it's a major issue. If there is, then, or if he can open it, then maybe it was something wrong with Sarah Boone's computer, the way she was trying to open it, whatever it may be. They are turning all this over to James Owens. So it is important that he is getting all this information so Sarah Boone can be effectively represented, which is what we should all want in this country. All right, next document here. This is the defense providing some reciprocal discovery. What is the defense sending to the state? Well, Julie F. Harper, Psy D. She is a licensed psychologist. Okay. Went to University of Denver. Looks like she graduated in 2001. She's been in private practice since 2010. Then her CV, she was a counselor, staff counselor, forensic psychology, has a predoctoral internship. So she's been doing it for a while. She has research experience. She's got a scholarship. She was on a radio show. She's been a speaker at different events. She's been an instructor. She was a preschool teacher prior to becoming a psychologist. That's interesting. American Psychological Association, Florida Psychological Association. And then she's got some references here. Okay. So this is going to be one of their experts, and they're providing her CV, AKA resume, to the state, which they should, which they have to. All right. Next up here, we have that is not the right one. I have all these documents when I open them up, just say doc on them. There we go. All right. So now we get into one of the more interesting parts of discussion for the video. And that is, we watched a couple of James Owens interviews. He said Sarah Boone was going to pay him. Sarah Boone owes him. They've got a plan they're setting up. He was retained, et cetera, et cetera. And that's perfectly fine. And I think people should get paid for their work. I also think lawyers should donate their time pro bono. Pro bono means good for the public, basically, that we as lawyers donate our time to help people in need, help good causes, whatever we want to do. I usually spend most of my pro bono hours helping my church, doing some legal work for my church, for charitable organizations that I support, for friends and family sometimes, depending on what it is. If it's a one-off, they need me to look at something for them, whatever it may be. I do pro bono hours every year. You have to turn them in. You have to certify them. We're going to talk about more of that later. But let's take a look now and discuss whether this was on retainer, pro bono. Does it matter? Why? Is anything shady going on here? That's what I think we need to kind of discuss, because a lot of people have been asking me that question. Comes now defendant Sarah Boone, buying through undersigned counsel, pursuant to these Florida rules, moves the court for ordering declarant or indigent for the purposes of due process costs and support thereof says. So I think we may have read this one already. I want to read it again just in context of another filing. Defendant Compton, I think that's a typo. Maybe we haven't read this because I feel like I would have caught that. Has been charged with second degree M. Defendant has previously been found indigent. And by the way, we don't need to hammer him too hard. Lots of lawyers use templates. They change the names. They change some of the stuff in the middle, the body of it. You do have to be careful. Lawyers should be attention to detail. You don't want to do this. It is embarrassing. But again, I'm not going to say, oh, he's a horrible lawyer or anything because there's a typo or another client's name in there. Undersigned counsel has agreed. Here we go. Undersigned counsel has agreed to accept this case pro bono and has not received any payments towards legal fees. So this seems to be an absolutely true and accurate statement that he has not received any payments toward legal fees. The defendant has been notified of the additional costs that will be noted for experts and investigators to fully investigate this case and prepare for trial in this matter. However, she is unable to pay for these costs. Undersigned counsel needs to fully investigate this case. Undersigned counsel feels the defendant's rights may be severely prejudiced if he is not able to fully investigate the case. This motion is made in good faith and for no other reason. Signed by James Owens. Okay. But next, we get to this. This is an indigent affidavit. Indigent for costs affidavit of attorney's fees. And this is Sarah Boone, not James Owens. But James Owens, it looks like he prepared it, obviously, because she doesn't have a word processing or a printer. So I assume he did it and had her sign it. I, Sarah Boone, am represented by James Owens, Esquire, in the above entitled action. The attorney has agreed to accept the case pro bono. No other compensation, things of value, or funds have been paid or are anticipated to be paid in the future to the attorney in this case from any other person or source. Under penalty of perjury, I declare that I have read the foregoing indigent for costs affidavit of attorney's fees and the facts stated in it are true. Find this interesting now. So it seems to contradict what he said in his interviews. And I said this while we watched those. It's between a lawyer and their client. These things can change. He can expect her to pay and then realize, okay, she's not going to be able to. I'm not going to hold it over her head. He may think she can't pay. Then she comes into money later and she does pay him. There's a lot of different things that can happen. But I find it interesting that he very clearly stated over and over again, she does owe him. She is going to pay him in the future. And then we find that he has taken it pro bono. And they asked him, and he didn't just say, yes, I took it pro bono. Yes, I took it pro bono. Yes, I'm doing it for free. He didn't say that in the interviews. He could have, but he didn't. And then very clearly in multiple motions now, he and Sarah Boone both say he's taking it pro bono. And Sarah Boone even clarifies that she's not anticipating paying him anything in the future. Daybreak. Owens might want to keep those interviews in based on what he said about George's family. I recall she expressed fear of George's family in the site interview. Yeah, I mean, as in any interview, there's some good, some bad, some ugly, right? You have to keep the stash through Movember, or maybe we'll bring it back again. Maybe it'll make its triumphant return before Movember. If you guys remind me, I will definitely do this. Sometimes I forget. I just do a stash randomly. How would you defend her? Dig the MC Escher, maybe Hammer, shirt. So I think, and again, I break this down on a video that's probably going to post in a couple weeks a little bit further, where we do kind of an overview of this case and kind of a higher level view and summary of it. But I think the best defense is he got in there himself. He wanted to get in there. I was messing with him. I was planning on taking him out, and I just passed out and fell asleep. There still could be some criminal activity there, but no way second degree, maybe involuntary. But I don't understand how she really gets around much less than that, because she said I zipped him up in the suitcase to the cops. So they were playing hide and seek. She drank, she passed out. I mean, she admitted so many things that you're limited in your theories as a defense attorney. But I break this down further in a future video. So stay tuned for that. Nina, I finally made it live. Peter, thank you for your unbiased coverage. Not many attorneys with your humility and kindness. I appreciate it, Nina. I think there are some out there. I think there are a lot of good lawyers, just like there are a lot of good cops, and sometimes bad cops get more notoriety. Sometimes bad lawyers do too. I appreciate this so much. I strive for this. It's very important to me. I do my best to be patient and ethical and calm and not a loose cannon. You know, as a kid, I had a short fuse. I had a temper issue. So, you know, a lot of things you gotta grow with and work through. So I'm still doing my best to deal with that. Is there a certain number of pro bono hours that are mandatory? It is in my state. So Lori, we're about to get there. We're very close to getting there. In fact, it's the next document we're going to look at. Is a successful battered spouse defense akin to not criminally responsible, where the person can be ordered to treatment, or is it just regular not guilty, free to go? It's an affirmative defense, not guilty. So it's like self-defense. You don't have to go get treatment after. It is self-defense. You know, you just made me think, because we've had a case, I think it was technically an insanity defense, not battered spouse. Pretty sure that's right. But now you got me second guessing myself. Good question. Who you with? And I would say I'm 90% sure about that, not 100% sure about that. Did Sarah start future inmate chaos in the courts? I don't think so. It takes a lot of time and energy and willpower to do what she's doing. I don't think a lot have that. Because you can get beaten down in this system, in this process. And if you go back and watch the Karen Reed breakdown I did of the 2020, even Karen Reed's getting beaten down and she's out of jail at home. And it's still incredibly difficult. So Sarah Boone is resolute. And you have to give her credit for that. Whatever you think of her, she is resolved. She's not going to get pushed around. She is going to advocate for herself. I can respect that. Again, we'll see what ends up coming out in court. If she's convicted and she did this, horrible, despicable, deserves the punishment that she gets, but we're not there yet. Traveling Teresa, can JAC deny costs since they have already paid for these types of experts before? JAC has spent over $71,000 already. I did not know that. I would have guessed even more potentially. Does this include the attorney's fees? I don't know if there was a resolution of that yet either. If they paid, they're not going to pay 15 three times. My guess is they're going to pay 15 total. But I also don't know if Owens is going to try to apply for some kind of state attorney's fees, because there is the option for that too. But again, that's not necessarily pro bono. But they can deny it. I don't think they're going to. I think they're going to still extend reasonable amounts of money for Sarah Boone. And I hope they do. I hope they do. As a taxpayer here, potentially coming out of my pocket, I hope they do it. This is a good use of taxes, in my opinion, too. Now, hold on. Not wasting the court's time and wasting lawyers' time and being a jerk to experts, but paying for experts for criminal defendants who can't pay for them themselves. I'm okay with that. Welcome to Mary Beth and all the new members. All right. Newbie, I'm going to save this till the end. I'm going to save this one till the end. Dorothy, can you take pro bono half case and make defense pay remainder, or is it all or nothing deal? So I'm going to answer this as I pull up this next document we're going to look at. So the answer is yes. You can take a case partially pro bono and partially paid. What that is also known as, in layman's terms, or in terms you guys have always heard of, is a discount, right? Lawyers are allowed to take a discount, and that could be good for the public. It could be good for an individual person, but it's not necessarily traditionally what I think about in pro bono. And I'll tell you what I traditionally think about as pro bono. We're going to read here from the Florida Bar Rules 4.6.1. And we're going to go in here to the comment section, okay? Because this is where it kind of describes what pro bono is, what the purpose is of pro bono, and then I'll give you kind of my understanding, but whether or not it's mandated is a little bit different. Pro bono legal service to the poor is an integral and particular part of a lawyer's pro bono public service responsibility. As our society has become one in which rights and responsibilities are increasingly defined in legal terms, access to legal services has become, ouch, I just kicked my desk, has become of critical importance. This is true for all people, be they rich, poor, or of moderate means. However, because the legal problems of the poor often involve areas of basic need, their inability to obtain legal services can have dire consequences. The vast unmet legal needs of the poor in Florida have been recognized by the Supreme Court of Florida and by several studies undertaken in Florida over the past 2 decades. The Supreme Court of Florida has further recognized the necessity of finding a solution to the problem of providing the poor greater access to legal services and the unique role of lawyers in our adversarial system, representing and defending persons against the actions and conducts of governmental entities, individuals, and non-governmental entities. So I'm just putting that there so I remember where I'm at. So these are comments at the bottom of the rule. This is why we have the rule. This is why these things get done. And usually lawyers or lay people or judges will say, hey, we need a rule for this. Send it to the rules committee. Make a rule on this. We've got to get this better. We've got to get this better. We've got to fix this problem. And so these are the kind of comments that come along with it. As an officer of the court, each member of the Florida Bar in good standing has a professional responsibility to provide pro bono legal services to the poor. So if you're a lawyer in Florida, you are responsible. You have to do this. We know it. We know we have to do this. We have got to provide pro bono services. Certain lawyers, however, are prohibited from performing legal services by constitutional, statutory, rule, or other regulatory prohibitions. Consequently, members of the judiciary and their staff, government lawyers who are prohibited from performing legal services by constitutional, statutory, rule, or regulatory prohibitions, members of the bar who are retired, inactive, or suspended, or who have been placed on inactive list for incapacity not related to the discipline, are deferred from participation in this program. So obviously, certain people can't do pro bono work. We're not going to read, maybe we'll read all of it. This is what I wanted to talk about here. In discharging the professional responsibility to provide pro bono legal service to the poor, each lawyer should, meaning you have to, furnish a minimum of 20 hours of pro bono legal services to the poor annually or contribute $350 to a legal aid organization. So, first glance, you guys tell me, do you think that's a lot? Do you think that's a little? Do you think, I mean, $350 seems like nothing for a lawyer to give to a legal aid. 20 hours though. Do you think 20 hours seems like a lot or a little? Now, if you say 20 hours at an hourly rate, it's a heck of a lot more than $350. I think when you hear 20 hours, it sounds low, but oh great. Here people have comments about this. Of course. Please hit on my pro bono service. Please do. Some churches are very poor. Some churches have no money and they definitely can't pay lawyers to do a lot of the legal services. Also, some churches help people who are in legal pickles and connect them with lawyers from the church. And I would consider that a service to the person and the church. So, but some churches are absolutely poor. Some are not. Some are very wealthy. But 20 hours, here's what I'll say, and I'll defend it a little bit. I think that we should do more. We should do as much as we can. But think of any other job that makes you work for 20 hours for free, right? Not all lawyers make a lot of money. Some do, some don't. So forcing them or demanding that they do 20 hours, I feel like that's a good amount. And I think it's a minimum. And they even say in here, it's a minimum. It is not a maximum. So a minimum is 20 hours. And a lot of people saying too low, and I get it. And that's why I wanted to ask to see what you guys think as the public. Most people don't have the best opinion of lawyers, so I understand that. And from my perspective, I think it's a good thing. I think it's a good cause. I think it's good for the public. And I think they should do it. I think 20 hours is fair. I do think 20 hours is fair. 20 hours a year, Azam. 20 hours every year. Okay. Yeah. So 20 hours annually. Pro bono legal service means legal services rendered without. So here's the part that, we're going to talk about a little bit with Owens, because this is what I always think of as pro bono. Okay. Pro bono legal service means legal service rendered without charge or expectation of a fee for the lawyer at the time of the service. The time the service commences. So it doesn't mean that you can't get paid later, but when you're taking the case, you do not expect to be paid. That's number one. Number two is this is not a mandate saying this is the only way you can do something pro bono. Okay? Because pro bono is kind of a term that people throw around. So what I would say is you can call something pro bono if you're not charging for it and you're helping a member of the public and you're doing it for free, but you're still hoping you get paid in the future. And maybe you just don't count it when you certify your 20 hours of pro bono service a year, right? You do 20 hours elsewhere, but you do even more than that. And some of the more than that you do is you take a chance on somebody, you say, you don't have to pay me, I'm going to do it. If you come into money later and you feel like paying me, great. That would be great. Or even, she owes me, she can pay me in the future, like he's doing with Sarah Boone. And, he's saying like, she's going to pay me, she's responsible. I make my clients make payments all the time. From my perspective, I think that's okay too. Maybe it doesn't qualify as the mandated 20 hours of pro bono service here we have in Florida, but I think it's okay to call it pro bono, not charge, and still hope she pays you in the future, or even expect to be paid in the future. I don't think it would be okay if you certified that at the time you took the case, you did not expect to be paid if you're saying things like, she's going to pay me, she owes me. Okay, let's keep reading here to finish up. Legal services written off as bad debts. Okay, so here's another thing. Do not count as pro bono services. So you say this costs 50 grand as a criminal case. They don't pay you. You write it off. You can't say, I did 1,000 hours of pro bono service on this case. Can't do it. Can't do it. Has to be pro bono. You have to know it's pro bono. So Lori, great question. There's the answer for my state. All right. Let me keep reading here. Most pro bono service should involve civil proceedings, given that the government must provide indigent representation in most criminal matters. So they don't expect a lot of pro bono criminal lawyers. Why is that? Well, because the state usually pays for criminal lawyers. And if they don't, then the criminal defendant usually pays for criminal lawyers. But you have an unusual circumstance here where Sarah Boone needs a lawyer. She can't pay for it. The state won't pay for it now because the judge said she's waived that right. And there we go. That's how we're here. And this even, understands that this is not a normal thing. Pro bono legal service to the poor is to be provided not only to those persons whose household incomes are below the federal poverty standard, but also to those persons frequently referred to as the working poor. So they didn't want to put like a line where it only counts for pro bono if somebody makes less money. And one of the reasons for that is like, what are we supposed to do as lawyers? Like, hey, give me your tax returns before I help you out for free. Pro bono legal service to the poor is provided to only, is to be provided. Oh, sorry, I already read that. Lawyers providing pro bono service on their own need not undertake an investigation to determine the client eligibility. Rather, a good faith determination by a lawyer of client eligibility is sufficient. Pro bono legal service to the poor need not be provided only through legal services to individuals. It can also be provided through legal services to charitable, religious, or educational organization whose overall mission and activities are designed predominantly to address the needs of the poor. For example, legal services to organizations such as the church, civic, or community service organizations relating to a project seeking to address the problems of the poor would qualify. Additionally, why I like doing pro bono services to charitable organizations or churches is they spend a lot of money, time, and resources helping way more underprivileged people than I ever could. Their reach is usually sometimes nationwide, sometimes statewide, countywide, citywide, and I only touch and talk to as many people as I can, right? So sometimes helping them save money on lawyer fees can help them spend money giving kids clothes and backpacks for schools, helping people in need, helping people move when they need it if they can't afford a mover, and sending people from the church there, whatever it may be. A benevolence fund when somebody loses their job and can't pay their rent and the church can give them money for their rent. Like that type of stuff to me is awesome and amazing that these churches and charitable organizations do. So if I can save them money on legal fees, sometimes that can be exponentially good for the public, right? And helping individuals is important too, but sometimes helping bigger entities is good too. And that's why they even put that in here. While the personal involvement of each lawyer in the provision of pro bono legal services to the poor is generally preferable, such personal involvement may not always be possible or produce the ultimate desired result. That is a significant maximum increase in the quantity and quality of legal services provided to the poor. The annual contribution alternative recognizes a lawyer's professional responsibility to provide financial assistance to increase and improve the delivery of legal service to the poor when a lawyer cannot or decides not to provide legal services to the poor through the contribution of time. Also, there is no prohibition against a lawyer contributing a combination of hours and financial support. The limited provision allowing for collective satisfaction of the 20-hour standard recognizes the importance of encouraging law firms to undertake the pro bono legal representation of the poor in substantial, complex manners, requiring significant expenditures of the law firm resources and time and costs, such as class actions and post-conviction death and penalty appeal cases, and through the establishment of full-time community or public service staffs. When a law firm uses collective satisfaction, the total hours of legal services provided in such substantial, complex matters or through a full-time community or public service staff should be credited among the firm's lawyers in a fair and reasonable manner as determined by the firm. So you take on a case as a firm, you handle it as a firm. So we promote it. I just had one of my lawyers ask me, hey, can I do this case pro bono? Do you mind? And sometimes it is harder. Like if you're an employee as a lawyer, will your boss let you just take 20 hours and not bill and not make them money, but go work pro bono? Every lawyer in Florida and in America should say yes to that, by the way, which we always do. And we encourage it and promote it. But you would understand some law firms might not. And that's why as a lawyer, maybe you just pay the $350. The reporting requirement is designed to provide a sound basis for evaluating the results achieved by this rule, reveal the strengths and weaknesses of the pro bono plan, and to remind lawyers of their professional responsibility under this rule. The fourth alternative of the reporting requirement allows members to indicate that they have fulfilled the service in some manner not specifically envisioned by the plan. So it's like you can also say, hey, I did this other thing that I think qualifies, and they'll take a look at it and they'll consider it because, again, they want to promote this. This is good stuff. This is good stuff. The 20-hour standard for the provision of pro bono legal service to the poor is a minimum. Additional hours of service are to be encouraged. Many lawyers, as they have before the adoption of this rule, contribute many more hours than the minimum to ensure that a lawyer receives credit for the time required to handle a particularly involved matter. This rule provides that a lawyer may carry forward over the next 2 successive years any time expended in excess of 20 hours. So you take a big case, you spend 60 hours on it, you can use that, or I should say 40 hours, you can use that over the next 2 years as well. They can kind of roll over or carry over. Debbie, great question. So you can carry them over the successive 2 years. Okay, let me answer a few questions, and then we're going to get to the last filing that I'm not saying, I'm just saying, okay? Trey, is there no criminal charge for torture? Wasn't he essentially tortured before he died? Thoughts? Love your channel. So yes, that could be, battery. That could be false imprisonment. There are all sorts of charges you can throw at it. But when you have the second degree murder charge, usually you don't tack on stuff like that. So yeah, there are other things you can charge, but usually you charge the most serious thing. They could have charged multiple things, but you can charge all the lesser includeds, but usually the way you do it is exactly how they do it. They did it. Surprised they're not going with blackout. I've only blacked out once while drinking and I did things. I have no memory of I was told the next day that I would never have done had I been aware of what I was doing. Yeah. And I had friends talk about this in college. It's one of the reasons why I don't drink and don't ever really care to is I'm a control freak. I don't want to be out of control. I don't want this to ever happen to me where somebody's like, hey dude, you are not going to believe what you did last night. And that would mortify me, especially as a dad with kids, with a reputation, with a wife. That would suck with clients. But voluntary intoxication in Florida is not a defense. So if you choose to get drunk or take pills and you black out, that's not usually a defense. But if you don't have the criminal intent and you were getting blackout and you didn't want to hurt him, again, that could potentially get you a lesser included and not the heaviest charge if it goes to the mens rea. Peter, can you include one of your videos, all of the previous dates and times Sarah Boone and George had police or others contacted for DV due to their behavior? So, Pesky Pirouette, what I'll probably do instead of this is when it comes out of trial, because this trial is starting in less than a month, October 7th. Isn't that wild? I want to see how it comes out. I want to see what the judge finds to be reliable, not just accusations or call outs or things like that, but what does the state actually bring in? What does the defense actually bring in about the back and forth of the domestic issues in this relationship going back and forth? Heather, if you take a case pro bono and it takes more than 20 hours, do you have to stay on the case? It's a great question. Usually a judge will not force you to stay on for free, but they would probably give you a good scolding and say, why'd you take this case? If the case is almost over, they may force you to stay on it. If it's just in the beginning, they may be like, why did you take this case? Lawyers should know this stuff. A lot of responsibility is put on our shoulders to know what's going on and be experienced to realize that this case isn't going to be done in a day. So usually that's why it's a lot of one-off things. It's a lot of maybe looking at some documents or drafting some documents. It's not usually taking a case through trial. Those aren't usually the cases you take pro bono. But sometimes you do, and sometimes you can. All right, let me bring up this last document here I wanted to look at real quick. So this is what we call a notice of unavailability. Peter, what's a notice of unavailability? In an abundance of caution, if you have a case that stuff's happening fast and furious, you maybe are afraid of being blamed for some delays, you want to say, hey, listen, everybody, I'm out of town. I can't do this. I can't work on these days. So we can't schedule trial, hearings, depots, or anything that I have to respond to immediately on these days. Now, you can't put notice of unavailability for a year, unless, of course, you're in a trial. If you're in a year-long trial, you can do that notice of unavailability. Like the YSL lawyers, my guess is they're filing notices of unavailability in all their cases. So the judges can't sanction them. They can't force them to do something. They can't hurt their clients. They can't get railroaded while they're in another trial. So you notify everybody. Then this is the vehicle in which you're able to do that in Florida and a lot of other jurisdictions. A notice of unavailability puts everybody on notice that you cannot do certain things during this time period. So let's take a look at it. Comes now the undersigned assistant state attorney. This is Cacciatore, who's been handling the case, been primary on most of the hearings, and hereby gives notice that he will be unavailable for depositions, hearings, and trials beginning when? December 16th through December 20th of this year. Why did I find this interesting? Well, this trial is starting October 7th. And this trial is supposed to last 2 to 3 weeks, maybe a little longer if jury selection goes long. So at the latest, potentially November 7th, maybe it takes a month. So why is he filing notice of unavailability for December 16th in this case? There are 2 or 3 potential reasons for that. The most likely reason and the least shock and awe reason is just that he filed it in every single one of his cases. Every case that he's assigned to, he told his paralegal, hey, file it in every case. And he filed it in every case, regardless of when the case is supposed to be resolved, go to trial, et cetera, et cetera. So maybe that's what he did, and he didn't want to look through, okay, this one's going to be done, this one's not going to be done. Maybe that would have taken more time than just putting it in. Option number 2, Sarah Boone's trial ends in November and sentencing or some post-trial motion that she files, some appellate motion that he may have to be involved in, whatever it may be, he is not available on these dates. So he wants to put everybody on notice of that. Or third, maybe he thinks this trial might get continued. Maybe he thinks this trial might last 3 months. I don't think that's likely, but in the event that this happens, in the event something happens here with discovery, James Owens gets more information, makes a better argument, gets the case continued, he wants to make sure the judge knows, do not set another trial on December 16th through the 20th, Judge. I am putting everybody on notice. And when you do it ahead of time, the judge is very likely to respect that and say, okay, listen, he put us on notice. We're not going to set it during these dates. Sarah Boone, you can complain and say speedy trial is not happening, even though it wouldn't make sense because she's the one asking for these continuances. But it's not going to be set during these dates when Cacciatore is unavailable. I thought it was interesting. When I saw it, it just made me raise my eyebrow a little bit. I was like, okay, let's discuss this with the fam, Let's see what the fam has to say. All right. Let me get to the last couple questions. Yeah, doesn't bother me whether he's taking a vacation or anything like that, but just think it's interesting that he did that. So Newbie asked, Peter, how are you liking The Perfect Couple? So here's what I'll say about it. This is a show on Netflix that my wife was like, oh, I read the book. I want to watch it. So we watch it. I love mysteries. I love things with twists and turns. I love stuff that keeps your attention. And I will say so far it's done that. It's kept my attention. There are some slow parts. There are some parts we skip through. It is wildly intertwined with relationships, which just shows exactly how ugly that can get. We are 4 episodes in out of 6. We got 2 more left. We'll probably finish over the next day or two, the last 2 episodes. And then I'll give more of a complete review. But I honestly have such a low bar for shows these days because I love watching stuff with my wife. She's hilarious when we, talk through this stuff, or she's like, whoa, I can't believe this, blah, blah. And so, I have fun watching these kinds of shows, and we're always looking for something to watch together. So it's fun to have a show to watch together. It's not my favorite show in the world, but I don't hate it. We'll see how it ends up and what the ending is like. All right. That's all we got. Thank you, everybody who joined. Please hit that like button and make sure you subscribe. If you have not subscribed to our page, make sure you subscribe. Sarah Boone's trial starts in less than a month. I'm going to be going over there for at least a day or 2 of it. So please let me know if anybody's going to be over there. And we're not going to make it a show. We're not going to make it crazy or a circus or affect the trial at all. We got to make sure of that. We're all going to agree to that before, that trial starts here, at least in this community. But I appreciate you guys so much. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.